Great, thank you. I'm happy to be here with Savvy Ladies, and we are talking today about workplace discrimination. What I'm going to do is to sort of start a little bit bigger picture based on the sort of questions I tend to get from people who are calling our office. Maybe it's the first time they're calling a lawyer, maybe it's the first time they're thinking that they might have experienced discrimination or having questions about it. And then we'll sort of dive in to a little bit more of the nitty-gritty on the applicable laws. So I wanted to just start off, we're going to focus on gender discrimination today, but I did want to touch on the common types of workplace discrimination, because as anyone with a working understanding of intersectional feminism knows, different types of discrimination sort of impact each other. And for example, women of color experience both race discrimination and gender discrimination in a way that's different from only race or only gender discrimination. So race discrimination in the workplace can include anything from physical appearance to national origin, and can even include things like clothing or hairstyle choices. New York City, for example, recently passed a law eliminating discrimination against certain traditionally African American hairstyles, which is very forward thinking, and but also, you know, badly necessary, because that's one of many ways in which African American people are discriminated against in the workplace. This includes actual race or perceived. So you don't have to know, you know, the person can get it wrong and it's still illegal if they're being discriminatory. Gender discrimination, of course, includes, you know, sexual harassment, hostile work environment, quid pro quo, all the different forms we're going to talk about today. And it covers, it can cover gender identity and sexual orientation, depending on where one is. These are protected classes in New York City and New York State, although there's litigation right now before the Supreme Court to determine whether sexual orientation is covered under federal anti-discrimination statutes. But gender discrimination also encompasses conformity to traditional gender roles. So for example, if a woman is accused of failing to adhere to certain, you know, quote unquote feminine stereotypes, that can count as gender discrimination. Another common type of workplace discrimination we see is age. Age discrimination unequivocally hits women harder for many sociological reasons outside the scope of this conversation, but we usually see age discrimination against older workers, where an older worker might be described as out of touch, you know, they don't get it, the company wants to move in a different direction, the company wants young blood, a fresh perspective. There's a lot of sort of code words that tend to indicate age discrimination. Anytime somebody is forced to retire, pressured to retire, and of course age discrimination is extremely insidious in the hiring process against women, but also very difficult to prove. Pregnancy and caregiver discrimination. Now, pregnancy discrimination falls under gender discrimination under the federal, state, and city laws, but caregiver discrimination is kind of a newer theory, something that's just starting to show up in the laws. New York City has a caregiver discrimination prohibition, and this includes a number of subsets. For example, rights around nursing, pumping, and of course for either parent, you know, having to deal with childcare responsibilities or any other family member. Caregiver discrimination doesn't just include babies. It can mean I have to, you know, I have an elderly parent I'm taking care of, which of course we see a lot of, and which is another burden that tends to fall disproportionately on women. Lastly, disability and medical discrimination is another very common issue where, and this tends to intersect with pregnancy discrimination. If somebody is having needs reasonable accommodations in the workplace, or is having mental health issues, for example. Employers are supposed to, in most cases, provide a reasonable accommodation to sort of work around these issues, and instead, a lot of times we'll see people forced out of the workplace or pressured out, or unreasonably denied accommodations, which make it impossible for them to keep their jobs. So all of that is just sort of the backdrop, and we'll dive into gender discrimination specifically. But of course, during Q&A, I'm happy to discuss any forms of these. So one of the things that people are very reticent to speak with a lawyer, because accusing someone of sexism or of discrimination, it feels like a very heavy lift. And people tend to think, oh, I don't have proof. I don't know if I'm being discriminated against because nobody came outright and said, well, because you're a woman, we're treating you this way because you're a woman, or we're treating you this way because you're transgender. People don't tend to come out and say that outright. And what I want to encourage you to do is to think more broadly and to understand that courts can draw inferences, and you can take facts and draw conclusions from those facts. So somebody doesn't have to show up and say, I'm discriminating against you, in order for a court or for you or for us to make an inference that there is discrimination occurring. So what counts? Obviously, or I hope it's obvious, any sort of sexual harassment counts as gender discrimination, including negative comments, or any gestures, anything sexual in nature, anything unprofessional that has to do with gender or sexuality, all of that counts. Disparate treatment counts in any form. If you're getting a hard time for leaving early, whereas a man doesn't get a hard time for leaving early, or having to, well, there's a bunch of things that count, so then they all kind of blend together. But so just some examples to get the juices flowing. Disparate salaries, obviously. This one is harder to show unless you have opened the pipelines of communication with your coworkers, which is something we're going to circle back to. But different tasks assigned, if women are always asked to be the note takers or to get the coffee, or even just to do more of the emotional labor, to suck it up and grin and have to deal with more annoying people in a way that men aren't asked to do. Held to a higher standard. This is, and sexist code words. These are all sort of overlapping examples of ways that women are treated differently, where women are considered to be aggressive or bossy, or, as we've seen in the recent election, unlikable, which is, if one person likes you, then by definition you're likable. But it's the sort of code words that tend to be levied against women, where women are often expected to perform more of the emotional labor, to be more deferential, to be more polite, to be more obsequious, and it becomes very fuzzy in these situations where it's not necessarily so clear cut, but the more information you can gather together, the more of a pattern you can kind of establish. Whose behavior counts in terms of going after an employer, seeking justice, or really complaining about any sort of negative experiences? Companies have different obligations and different responsibilities depending on who is the bad actor. Whether it's a peer, a supervisor, or a client or customer, companies do have the responsibility to create a workplace that's free of discrimination. So if you have a peer who is a bad actor, whether sexually harassing, making negative comments, any of the previously enumerated examples, and you complain to the company has an obligation to rectify the situation or to do an investigation to figure out how to address the behavior. If it is your supervisor, the company has a higher burden. And in fact, in New York City, the employer can be held to be strictly liable for the supervisor's conduct, meaning that you can sue the company as well as the supervisor for the supervisor's bad behavior. That's another New York City law that individuals can be held liable, which is unusual. Under federal law, the employer can get out of liability for the supervisor, but only if they have an affirmative defense to, that's a type of burden shifting, where if the employer comes forward and says, well, we have these reporting mechanisms that you failed to take advantage of, then that can be a defense. And lastly, when it's a client or customer, these cases are a little bit trickier because naturally a company can't control the behavior of some rando walking into their store or calling their hotline. But if there is a pattern, or if there's a repeat offender, or any sort of situation where the employer does have control over the situation, they are obligated to fix it. And we have cases where, for example, a client was being sexually harassed by customers and the employer failed to take adequate remedial measures to prevent that kind of behavior. A few reminders: women can be the bad actors. Women can and do discriminate against women. Some people like to speculate over who's worse. Oh, women are worse because they're catty, or I don't believe any of that. Women and men can both discriminate against women or against anyone. And I also just like to give a general reminder, we're not always all in it together insofar as women of color have it worse as a general rule. And so I like to just give a reminder to, any white women who are watching to that I think we have an extra responsibility to our colleagues of color to step up and to report issues when we see them, because we do have more power in the workplace, whether we like it or not. The reason most people don't complain about discrimination and about sexual harassment is fear of retaliation. And so I want to take a minute just to talk about retaliation. Retaliation is its own thing. Many people rightfully fear retaliation, and so they don't complain because they understand that in the real world they can be penalized socially, which can equate to being penalized professionally, or in many instances outright demoted or with some other sort of adverse employment action. Now, it's important to understand that if you are punished for making a good faith discrimination complaint, whether or not the original complaint is provable or winnable or turns out to be correct, the employer is still not allowed to retaliate. So there have been cases where somebody made a good faith complaint of discrimination, the employer retaliated, and the employee won the case on retaliation, even though the court found the original complaint wasn't proven. So that's just something to keep in mind. Sometimes people think, oh, I don't want to get a lawyer involved because I know that will escalate the situation and the employer will just get mad and it will make it worse. The truth is, once we show up, for example, when we send a letter to the employer, anytime a lawyer gets involved, the other lawyers necessarily get involved. And once you've gotten a lawyer involved, once you've made a complaint, a formal complaint, in some ways you're more protected, because unless the employer is a total idiot and their lawyers are total idiots, then at a very minimum, they'll be advised, don't you dare fire this person. You can't fire someone after you get a letter from an attorney alleging gender discrimination. You're just asking for trouble. So in any event, it is important to complain, and it's important to keep a record of it to preserve your retaliation claims. If you're afraid that the company's going to retaliate against you, it's important to have a record that you've made this complaint. You don't have to make a formal complaint to have put the company on notice. So what I usually advise people is sometimes, well, actually we're going to get to that in a second with documentation, but you can get things in writing in subtle ways, especially with the more informal methods of communication that have sprung up technologically. by sending someone a text message or a G chat, or if you have Slack, a lot of these informal methods of communication feel more casual, but it's still in writing. So you have an evidentiary, you have a piece of evidence, but you don't have to feel like you've said, dear sir or madam, I hereby formally accuse thee of discrimination. You can send a text or a online message to a supervisor being like, hey, did you hear what he said? That seemed a little bit screwed up. I don't think he would have said that to Joe. So that leads us to what do I do about it? If you have any sort of suspicions whatsoever, the big piece of advice that I, as a lawyer, and that every lawyer will and should give you in the discrimination context or any other context is document. Document, document, document. Document everything. Save emails, text messages, etc. to your personal accounts or devices. This is a tiny bit of a controversial advice because you may have rules, confidentiality rules, that prohibit you from doing this. So just consider it kind of a general concept of keeping your own record of emails, text messages, any sort of work communications, because if you do get fired, you will likely immediately get locked out of your account. Now, as an aside, employers are obligated when there's any sort of threatened or contemplated litigation, employers are obligated to retain any and all relevant documents. So just because you're locked out of your account doesn't mean that that information is gone forever. It means you're entitled to it in discovery, but you don't have it right away, which makes it harder to kind of put all the facts together and to formulate a case. Check your local laws about recording conversations. New York State is a one-party consent state, which means that as long as one party to the conversation, i.e. you, consents, you can record any conversation, as long as you're there. You can't leave a device planted somewhere and leave and then eavesdrop. That's a criminal violation. But if you're there and you consent to the recording of your own conversation, that's perfectly legal. This is another sort of controversial issue. Some lawyers advise their clients not to record conversations, in part because you then may have a duty to preserve it and you may have to turn it over, in the event of litigation and discovery. I tend to sort of evaluate on a case-by-case basis, although I will give the important caveat that most people who come to me having secretly recorded a conversation, the conversation doesn't sound as good as they think it does. It usually just sounds like people arguing, and it could sound like you sort of manufactured the situation because you were recording it, and it all depends. When there's sexual harassment, definitely I usually say yes, record, because they're going to deny that they said it, and then you have it. And lastly, write down everything. Reach out to witnesses. This is what I was talking earlier about Slack, text messages. You can, if you have a friendly coworker and you can just start a text thread, all of that counts as evidence. And if you keep a diary at home, that can count as evidence. If you sent an email to your friend, to your spouse, saying, oh, you won't believe what happened to me today, all of that counts. So just the important thing is to get it in writing in whatever form that means. It doesn't have to be something formal. Okay, so other than document, what else to be done, practically speaking? Form alliances. I cannot stress enough how important this is. There is strength in numbers. You, not only for information sharing, but for moral support. It's hugely important to have somebody on your side. And it is also important to share information. One person complaining can be couched as a he said, she said situation, or, oh, she just, she thinks she's experiencing discrimination, but really she's just a poor performer. I mean, we hear that in literally every single case. Some sort of performance issues come up after the fact. With two or more people working together, it makes it much more difficult to make those sort of performance claims. reach out to HR. Yes, HR is there to protect the company, but a lot of times the best way to protect the company is to deal with a problem. So a good HR department will recognize that sweeping problems under the rug might not be in the company's best interest, and also you're creating a paper trail. Reach out to an employment attorney. We are here to help. This is what we do every day. So please, don't wait until something horrible has happened. We have a lot of clients where we've gotten involved while the person is still employed, and we show up and we say, we're here to help de-escalate the situation. We want to address this before things go off the rails, and we've had success with that. So, depending on what your goals are, there's really no need to wait to reach out. If you're in a union, we advise you very strongly to loop in your union. They have resources that you can use. They have pre-existing rules for the company to follow. They have their own grievance procedures. Best of all, union representation is of no cost to you. That's the benefit to you of being in a union. Some unions, of course, are better than others. We've had lots of clients where the union just did nothing, and so it is what it is, but there's no harm in reaching out. All right, so that's sort of the global strategic map, and I wanted to dive into the laws that govern us. I don't know if we're all here in New York City, or most of us are in New York City, so we're going to touch on the New York City, New York State, and federal laws. So this next slide is the preamble. It's part of the preamble to the New York City human rights law, and I love it, so I always read it, and I turn to it regularly. It says, in the city of New York, with its great cosmopolitan population, there is no greater danger to the health, morals, safety, and welfare of the city and its inhabitants than the existence of groups prejudiced against one another and antagonistic to each other because of their actual or perceived differences. And the statement that there is no greater danger, I think it's a very strong one. It's a very powerful statement that reflects New York City's wonderful commitment to equality and human rights. And New York City's laws really do reflect that, both their laws and their procedures. New York City has a wonderful Human Rights Commission that is very active and very dedicated to listening and to improve their processes. And New York City also has sort of a gold standard of human rights laws. We have wonderful human rights laws with unlimited punitive damages, individual liability against supervisors. It's great. Lower standard to prove what constitutes discrimination. So to dive into the details, we just sort of listed out just a couple of New York City statutes that are relevant and applicable for thinking about discrimination in the workplace and what are your rights in the workplace. So the human rights law in New York City covers many protected classes. This is only a small handful that we listed here. Age, race, color, sexual orientation, gender, disability, caregiver status, and importantly, there's a bunch of new laws pertaining to whether you're a victim of domestic violence or sexual assault. Specific protections in New York City. Employer liability for managers and supervisors. As we said, there is strict liability, meaning it's hard for them to evade their responsibilities to, the company has a very high standard of liability for the behavior of its managers and its supervisors. And also those individuals can be found to be liable. Reasonable accommodations are required for disability, not only disability, but pregnancy and childbirth. And also, if you were a victim of domestic violence, sexual assault, or stalking, you're entitled to a reasonable accommodation for that too. New York City does not permit employers to ask about your salary history in the hiring process, and that is specifically in recognition of historical salary disparities. And New York City also prohibits retaliation against employees speaking up about discrimination, whether on behalf of oneself or as a bystander. New York City has excellent earned, safe, and sick time laws. So you are entitled to sick time for to deal with your own illness, injury, medical condition, but also safe time. If you have to need time off to deal with a domestic violence matter, sexual assault or stalking, or a family member's, you're entitled to time off for that. And the law prohibits retaliation for using or requesting such time. There is also, finally, in terms of New York City, the Stop Sexual Harassment in New York City Act, beginning in 2019. Sexual harassment training, I realize we still have a lot to cover, so I'm going to speed it up a tiny bit. Employers must have an internal complaint process available to address sexual harassment claims. Retaliation prohibited, and annual sexual harassment training is mandatory. Sexual harassment, it's a hot issue right now with the Me Too movement. I really can't state enough how pervasive sexual harassment is in so many different industries. It's mind-blowing. And it truly is a way to keep, women and gender non-conforming folks oppressed. That's what it is. And I'm happy that New York City recognizes that. New York State also has great laws, especially since turning blue. The legislature has gone bananas with sort of a wish list from an employee advocacy standpoint, and I know a bunch of other standpoints. The big, huge news, New York State news in recent years is paid family leave, which is now a couple years old, but we're still implementing it each year. The amount of time increases and the amount of pay increases. So New York City provides job-protected paid family leave that's administered through the workers' comp system. So it's of no cost to employer. It's like a tiny cost that is passed on to the employee through the workers' comp system. But basically, it's a type of insurance, and so employees are entitled to. It's now up to around $840 a week for up to 10 weeks. New York State also, SONDA and GENDA added sexual orientation and gender identity and gender expression as protected classes within New York State. New York State human rights law has new language that it's designed to be construed very liberally, even when the federal laws are not as liberal. It prohibits harassment based on any protected class. Under federal law, the standard for establishing a hostile work environment is that the harassment must be severe and pervasive. That's no longer the case under New York State law. And also there's a prohibition on paying members of a protected class a lower wage for equal or substantially the same work. I'm going to upcoming in 2020, this is all going to be part of the handout, so we'll just go through it very quickly. The big thing is that the human rights law will apply to all employers, including those fewer than 4 employees. And also the statute of limitations for sexual harassment claims is increased from 1 year to 3, and that's for purposes of using the administrative agencies. There's a couple, as an aside, there's a couple different ways you can bring a case. You can bring it, and if you have federal claims and you want to bring it in federal court, there's an administrative prerequisite where you go to the EEOC first, and then after a 6-month period, you can file in federal court. But there's also state and city human rights agencies where you can file your complaint either with the New York City Human Rights Commission or the New York State Division of Human Rights. And those are sort of easier processes, especially for unrepresented litigants. And those agencies will actually conduct investigations and issue their own findings. New York City is better than New York State, I think, from an employee standpoint. The federal laws are not as good as New York State and city laws substantively, but federal court tends to be the most streamlined and efficient process. It tends to be sort of the fastest process with judges who take the cases the most seriously, and it's kind of the most formal process. State court can tend to languish on, and so my firm will bring cases in federal court wherever we can if we have both federal and state and city claims. Federal law that applies to these cases is Title VII, which applies to employers of 15 or more. We have the EEOC, the Equal Employment Opportunity Commission, which is charged with enforcing workplace laws, and that's the administrative body that you have to go to before you can go to court. EEOC does conduct investigations, mediations. They'll try to resolve any cases if possible before going to court, which of course benefits the courts that are always notoriously overworked at every level. And so they try to use the EEOC if they can to clear their docket. Pregnancy discrimination is part of Title VII as amended, so prohibits discrimination on the basis of pregnancy, childbirth, or related conditions. And also, with Supreme Court case law, sets standards for accommodations for pregnant employees that employers are required to give. They must give, employers can't discriminate against pregnant employees by giving accommodations to some and not others. So the federal law doesn't say you must give accommodations, unfortunately, but it does say that you must give equivalent accommodations. The Family and Medical Leave Act, FMLA, comes into play very often with childbirth and related issues, provides job-protected unpaid leave, very important to note, to care for a new child, seriously ill family member, or oneself, and that does include mental health issues. The Age Discrimination in Employment Act involves discrimination against older workers, and then of course the Americans with Disabilities Act also will give you this handout so you have a little bit more of the details. Requires employers to give reasonable accommodation, covers a wide range of disabilities for which discrimination is prohibited. So I think that gets us to the end of our slide. I want to leave time for questions. Here is our contact information. I encourage you to reach out to us. There's more information on our website, including how to reach us, of course, but also how to reach some other nonprofits we partner with and that we recommend, including A Better Balance, which has a hotline that you can call with questions especially related to pregnancy discrimination and paid family leave, and the Gender Equality Law Center, where I'm very proud to be the president of the board of directors. And they also operate a hotline, and they represent employees in all kinds of discrimination matters and sexual harassment matters, also discrimination in the in the educational context. So that's us. Thank you for watching, and I'd love to know if anybody has any questions.
Great, thank you, Susan. That was really excellent. I'll remind everyone, if you have a question, you can use the chat box, or you can email info@savvyladies.org. And I did see we had a question come in during the presentation, which is asking if discrimination cases are protected with any level of privacy, or if they're part of the public record.
That is a great question. Okay. In general, they are part of the public record. Now, when you file at EEOC, that is confidential. So if you're filing in a federal case, and actually, in fact, I'm gonna double check this because I want to make 100% sure I'm giving you the right answer. But my belief is that cases before the New York City Human Rights Commission are not a matter of public record, and the same is true at cases at the EEOC. So, but once you've gone through the administrative process, a court case is a matter of public record, and people are, you're right to be concerned about that because you can be seen as a troublemaker. There are cases where people have been permitted to proceed anonymously, and the law is always evolving on that, but especially where the allegations are especially sort of embarrassing or sexual in nature or private in nature, there are ways that you can file anonymously and that you can ask the court to permit you to proceed anonymously. But in general, yes, filing is a matter of public record. Now, typically speaking, employers, it's a little bit of a game of chicken because employees don't want the publicity associated with these cases, but employers don't either. And so we, like every attorney, we start usually by sending a letter to the employer where we say, here's the facts as we understand them, here's the laws that we think you violated. Is this something you're interested in discussing an early confidential resolution? And most employers are interested in that. if they take the claim seriously, which hopefully they should, because we don't go around asserting bogus claims. But that is, there's usually an opportunity to try to discuss a confidential resolution. And if that doesn't work, you kind of have to play it by ear and say, you know, what am I willing to do? What do I feel like doing? What's my employment status? It might depend. If you have a new job, you might feel more comfortable, but some people are more concerned than others, and rightfully so. And there's no clean answer to that, other than in many cases it is possible to seek leave to proceed anonymously.
Okay, great. Thanks, Susan. And I see we have a few more questions for you. The next one is about age discrimination, and it's asking, I'm a middle-aged woman and I experience age discrimination in seeking employment all the time. Is there any protection for job seekers?
So I feel for you, and I believe you 100%, because we get a lot of these inquiries. The truth about failure to hire cases is they're very difficult because employers are, it's easy for them to find some sort of pretext, and it's just, they're hard to prove. So usually it's not the sort of case that, and I'm speaking very pragmatically, which is, this is sort of one of my pet issues, because it's one of the situations for which the legal remedy I think is most inadequate. I've talked to so many older women who have trouble getting hired, and they know it's because they're an older woman, and I know that too, and the employers know that too. But it's very, very hard to prove that, you know, an employer confronted with a stack of resumes pulled yours out of the pile for this particular reason. And so I think it's not usually worth pursuing. I hate to say that, but that's sort of the practical reality. I don't know. I'm sure there are other lawyers who would disagree with me, and I would love to find those lawyers who would take these cases, because it's horrible. I know what happens. I'm sorry.
Okay.
Better answer.
That's all right. Okay. Thanks, Susan. Another question is asking what to expect financially if someone were to make a claim and then proceed with a case. Can you discuss the costs? For some of us, it might not make financial sense to have the legal fees when it'd just be easier to keep getting a salary.
Yes, that is a great question. So what we do, and what I think most employment discrimination attorneys do, is first we ask, what are your goals? If your goal is to remain employed, then you're right. We would charge an hourly rate, and you know, you just have to do the analysis. There are nonprofits, the Gender Equality Law Center, who represents individuals pro bono who can't afford legal services, and so I always encourage everyone to reach out to them. They're wonderful. If you've been fired, then the calculus becomes different, and we and most employment discrimination attorneys will consider taking such a case on a contingency basis, where we just take a percentage of whatever we get at the end. What we'll also often do in a case where maybe there's severance on the table, but you're looking to negotiate more, where it's not the sort of case, a case that's maybe in the middle, where it's not super clear cut, but we have a suspicion of what's going on. We offer a hybrid retainer where we charge a reduced hourly rate and a smaller contingency percentage. The calculus of whether it's financially worth it to pursue something is always sort of one of the early steps for us of evaluating a case, because it really, it depends on your salary. I mean, it depends on your resources, whether you have the means to pursue a case. It depends on how strong your case is, whether we or another attorney is likely to be willing to take it on contingency, because some cases are much more clear-cut than others. We have some clients where, you know, they told the employer they were pregnant, and they, within 12 hours, they were let go after they only received positive performance reviews up until then. It's like, we'll take that on contingency. You don't need to pay anything out of pocket for those. So it's very much a case-by-case basis. It's never worth it to put yourself in a financially worse position unless you have such unlimited means and justice is so important to you that you say, I don't care what it costs me personally, I want to send a message. Most people, I don't think that way, and there's no right answer. But I do say, encourage people, reach out to us, and we'll help you think it through. And if it's not perhaps financially possible to work with us, maybe it's something that the Gender Equality Law Center would be willing to handle if they have the capacity. The first step is reaching out, and we'll help you think through the finances. I don't know, did that answer the question, I hope?
I believe so. Yes, thank you. I'll move on to the next question, which is saying, I'm wondering if Susan has seen any improvement, like a decrease, in workplace sexual harassment over her career. Are things getting better or changing in any way?
I think so. This is something that I'm going to answer on behalf of my colleagues who have had much longer careers than I have, because I'm fortunate to work with, for example, Allegra Fishel, the founder of the Gender Equality Law Center, and there's a close-knit community of plaintiffs, employment discrimination attorneys who share information and resources and strategies and all that. So from what I've heard from those who've been practicing longer than I've been alive is yes, 100%. Things are getting way better. There's been a sea change over the decades in terms of, even having the language to articulate that sexual harassment is a problem. I mean, that wasn't always true in, some people's lifetimes. And let alone, the laws are getting slowly but surely better and better over time. Even within the past few years with the Me Too movement, we're getting less resistance to these sort of cases. Now, the big problems continue to be shame and stigma associated with being a victim, and that is still totally true. You hear these certain psychotic right-wingers going on TV saying, oh, there's this coveted victim status. That is baloney. There's a lot of shame and a lot of stigma around being a victim of sexual harassment, sexual assault, or even gender discrimination. People feel very uncertain about coming forward, and we still see that a lot. I truly believe that the biggest change that's happening right now is the one that needs to happen, which is a cultural shift, where we say it's not shameful. I shouldn't have to feel shamed because I was a victim. But it's hard. It's very hard. So yes and no, but mostly yes.
Okay, great, thanks. And this is the last question for you, Susan, which is wondering if hostile work environments are similar in New Jersey, and what about other states?
I do not know, because I'm only familiar with New York State, New York City, and federal law, but I will do the research and get back to you, because it's something that I've been needing to learn for my own curiosity, if that's okay.
Sure. Thanks for doing the research so we can send that information out later. So I want to thank you, Susan, for a really great presentation, and thanks to everyone for joining us today. As I mentioned, we'll be sending out follow-up information, so if you didn't get to write down Susan's contact information, we'll send that and some follow-up material. So thank you again so much, Susan.
Thank you, my pleasure.
Bye-bye.